It's a great pleasure for me to return after many, many years to the University of Waterloo to reacquaint and have a chance to chat with some longtime friends and to make some new ones. I've quite enjoyed my visit and look forward to returning again sometime. What I'd like to talk to, as Whitney said, is one aspect of the much more complicated treaty history story. And what I'm going to focus on today is some of the events that occurred in this region, in Ontario, and I've given it the subtitle, Redefining the Relationship. Because Ontario was the site of not one, but two redefinitions of the treaty relationship between First Nations and the Crown over time. The first redefinition came with the Royal Proclamation of 1763, which shaped events subsequently in Upper Canada. And within the Canadas, then Canada West, the Robinson Treaties of 1850 reoriented treaty making yet again, bringing a new emphasis on making treaties not in future agricultural areas, but in areas rich in natural resources, essentially shield country. And this focus that began to develop in 1850 was confirmed again in Treaty 9, 1905-1906 in Northern Ontario, the James Bay Treaty, as it's sometimes known. Now, to say that this is where the relationship was redefined, of course, leads logically to the question, well, then what was redefined? What was the relationship prior to the Royal Proclamation and events in Upper Canada and Ontario? And in these early years, the relationship was really focused on commercial relations and commercial agreements, commercial compacts, I call them, and on treaties of peace and friendship. That's really what had preceded the Ontario phase, and they really developed coincidentally, simultaneously, for similar reasons. Whether you're talking about the fur trade, particularly the beaver trade, or whether you're talking about winning First Nations allies for European powers in the great rivalries for control of this continent, you're talking about the necessity to make agreements. And when you're talking about the necessity to make agreements and have relations with Aboriginal peoples, you enter into a whole new cultural world, and Europeans had to learn this, and learn it very quickly. And what they learned was that for First Nations, it was not possible just to go in and to begin trade, just without any ado, without any preparation. Because First Nations didn't operate like that. They didn't operate like that because it wasn't safe to operate like that. They could not have commercial or diplomatic relations with people whom they did not know in their world. They had to assume that anyone who was not a friend or kin was potentially a dangerous enemy. So the Europeans found themselves drawn into a world of kinship creation, kin manufacturers, which was the indigenous way of establishing relationships among themselves. The Europeans had to step into and adapt to First Nations ways and protocols for doing things. And we see this happening very, very clearly in the fur trade from the earliest days, but perhaps reaching its best documented heights in Hudson's Bay Company trade of the West and Northwest. And what does it mean to say you make kin through ceremony? It means that there are elaborate rituals or protocols, if you wish, through which you go either to make that relationship, fictive kinship, anthropologists would call it, or subsequently to renew it. And it consisted of things such as the formal welcome when the trading party came to the fur trade post, the discharge of a volley of muskets as the canoes, the artist took liberties here, as the canoes approached the fur trade post, and an answering thunder from the cannon at the fur trade post. They'd be greeted formally, they'd be escorted inside by the post commander, where another set of ceremonies would then unfold. Speeches inquiring after each other's health since the last time they had been together to trade. Gift giving, food, and above all, the smoking of the pipe. The smoking of the pipe with great solemnity and great significance in Aboriginal society, particularly First Nations society. So these ceremonies are not just rituals, they are making or renewing subsequently our relationships which had to exist if First Nations were to relate to Europeans. Europeans eventually fell into this and learned to deal with it. The same thing was true of the other aspect, the early pre-Royal Proclamation phase of treaty making, the peace and friendship aspect. Because the same necessity to make and to renew kinship ties in order to have a commercial relationship was at play, was in operation when it came to making diplomatic and military ties, essentially. And this was also of great importance to the Europeans. Samuel de Champlain found it very, very early in 1609 when he established a relationship with the Wendat or Huron, and immediately found himself drawn, it would help if I showed you the slide, wouldn't it? Immediately found himself drawn into fighting the Iroquois on the lake that later bore his name. To enter into commercial ties with First Nations was, whether you realized or not or wanted or not, to enter into a political relationship as well. The point was put very, very clearly by an Onondaga diplomat in 1735 in a speech to the governor of New York at Albany. And the diplomat said, "Trade and peace we take to be one thing." You didn't have one without the other, and you couldn't have either without kinship, and you didn't get kinship without ceremony. Commercial compacts, as I call the first phase of treaty making, and treaties of peace and friendship, which Europeans would say was a second phase, though First Nations would say they were coincidental in fact, are two sides of the same coin, and that coin is kinship, which is absolutely vital to understanding what's going on. Now, there was no better illustration of what I'm talking about, but the close linkage and the use of ceremony to do both, than this man, who might look like some kind of court dandy out of the court of George III, but is in fact Britain's most skillful forest diplomat of the 18th century. This is later Sir William Johnson. And Sir William was a successful fur trader in the Mohawk Valley of New York. He was married into the Five Nations, as they then were, later Six Nations, the Haudenosaunee, the Iroquois, married to clan matron Molly Brant. And he was the first head of the Indian Department for the northern area, at least when it was created in 1755. And he occupied that role till his death in 1774. Johnson was an extremely skilled and successful forest diplomat. He knew all the protocols. He was married into the community. He dealt with them in the fur trade. And so he was adept at councils, of making speeches, giving gifts, of smoking the pipe, and giving presents. All those things, basically. And he was an extremely good example of that way of operation, which was, I repeat, essentially a First Nations way of conducting business. And Johnson also is an exemplar of that peace and friendship era, which tends to dominate the 18th century in our relationship. Because his brother-in-law, Joseph Brant, all these brothers, Tecumseh, who of course would be the great leader of the Six Nations Reserve on the Grand River, not far from here, was one of the most potent allies and one of the people who, along with his sister, helped to hold Mohawk support for the British during what we like to call the American Rebellion. They call it the War of Independence, basically. It was a very clear example of how that was conducted. And really, Brant was the first of a number of similar leaders. Another who was extremely important, playing a very similar kind of role, both in what's involved and how it ends, is the great Shawnee leader Tecumseh, of course, who undertook absolute prodigies of diplomatic negotiation to try to forge an alliance of Western Interior Indians against the Americans. There's a long history of First Nations trying to forge alliances against American expansion, which was quite aggressive. And Tecumseh saw the British, as Brant saw the British, as a lesser of two evils. There were not nearly as many of them, and they did not create farms to nearly as rapidly or to nearly the same extent. And so they were examples of how these treaties of peace and friendship, the alliance systems, operated down to the War of 1812, when Unfortunately, Tecumseh's dream of holding back the Americans, like Brant's dream before him during the Revolutionary War, like Pontiac's dream before Brant in the wars of the 1760s, all came to an unsuccessful end. Ceremonies, kinship were also key to that whole process through the 18th century, through into the War of 1812. And that, along with the commercial compacts, are what are the first two phases, and that's the previous relationship that will be redefined in Upper Canada and Ontario beginning in the latter part of the 18th century. The redefinition is founded, and generally speaking adheres to, this document, the Royal Proclamation of 1763. The Royal Proclamation of 1763 is the single most important document in the whole history of treaty making, and one of the most important in the entire history of Native newcomer relations in this country. It is impossible to exaggerate its significance. The Royal Proclamation was a unilateral proclamation by the Crown, by George III, and it was issued in October of 1763 in order to put in order relations and institutions in the new colonies that Britain had acquired by conquest and the peace treaty from France. And most of it deals with boundaries and institutions of governance and judiciary in colonies such as Quebec, East and West Florida, and Grenada. For Quebec, for example, it establishes the boundaries. The most important was the western boundary. And it also establishes what's known as the Proclamation line, a line down the height of land of the Appalachian Mountains. And in the last 7 paragraphs, the Royal Proclamation gets to dealing with relations with Aboriginal people, and it says a number of very important things. It closes lands beyond the western boundary of Quebec and beyond the Proclamation line to settlement, so as not to rile them. It says you can't even go there to trade without a license from the government of the colony involved. It also goes on to extend a kind of recognition of territorial or possessory right on the part of First Nations. Because the Royal Proclamation describes the lands beyond the Proclamation line, beyond Quebec's western boundary as, quote, lands reserved to them as their hunting grounds, meaning First Nations hunting grounds. And then it goes on to say, but if they wish to dispose of them, here are the rules. If they wish to dispose of their lands, those lands beyond the boundaries that are reserved to them, they may do so, quote, only to us at a public meeting called for the purpose. And every one of those words is pregnant, every one of those words is potent. Because what they mean is, by us, they mean you may dispose the lands only to the Crown. No more chicanery, no more dealing with land speculators. If a land speculator purports to get a deed with some First Nations person, it doesn't count, it's invalid, it's not legal. They're trying to head off the kinds of troubles that had happened in and near the 13 colonies with Indian peoples. So, only to us, to the Crown. And only at a public meeting, so there's no kind of hole in corner work, no under the table dealing, so the community affected knows what's happening to their lands. And the meeting must be called for the purpose. No bait and switch. No calling me for one purpose and then doing something else where people don't expect it. Only to us, at a public meeting, called for the purpose. And that is treaty making. That is Britain's approach to making treaty. That is what will govern the third phase of treaty, which is the making of territorial treaties. And territorial treaties will be made because there will soon be massive immigration and settlement of non-native people, essentially. Now, there is a period in which the full impact of the settlement frontier in British North America does not play as severely on First Nations as it later would. And the reason for this is, in charge of Indian Department operations for a long time is a series of leaders, agents, officials, commissioners, who had been trained in what I like to call the William Johnson School of Forest Diplomacy. They shared the same attitudes and they knew how to work the same protocols and they knew how to relate to Aboriginal people. They related to them in commercial settings and in diplomatic military relationships. They respected them, and they knew how to deal with them. Men like James Johnson, Sir William's nephew, Daniel Klaus, James Klaus, James Gibbons, T.G. Anderson, and these were the people who tried to carry out a lot of policy down till about the 1840s in this region, and thereby soften the full blow of the coming of the settlement frontier. But they could only soften it, they couldn't prevent it. They certainly couldn't hold it up all that long. What happens is, in Upper Canada, Ontario, you get a succession of 3 waves or phases of territorial treaty making that will have an enormous impact on First Nations of this region. The first, in this map, are the treaties made between 1784 and 1812 along, quote, the front, along the river and the lakes. Because those waterways were the highways, there are no roads. And that's where settlers are going to go, so that's where you get access to land for settlers. These first territorial treaties in Upper Canada are characterized by 2 things. One is the persistence and prominence of ceremony again. The governors, negotiators, and council, these treaties making sessions invariably begin after the usual ceremonies, essentially. So ceremony is there. They're making and renewing kin, just as in the fur trade, just as with peace and friendship. And the other distinctive feature of the first phase of Upper Canadian treaty making is that the compensation at the Mississauga, it's almost all Mississauga First Nation to get. They give up the land and get compensation. Compensation takes the form of one-time payments in goods, according to the values expressed in pounds, essentially. And that allowed the peaceful settlement and access of the Loyalists after 1784, and the so-called late Loyalists, American immigrants, essentially, that came in the 1790s and later. The second phase comes after the War of 1812. And this is essentially a series of treaties that fills in the territory behind the front to a great extent. As a wave of British immigration comes, particularly after 1820, an enormous amount of land is needed to settle them peacefully. And again, it's via treaty which usually follows, not always perfectly, the Royal Proclamation rules for making these agreements. There are 2 differences in this phase that are really important. One is that the government, that is the Indian Department, the British Indian Department, begins to talk in terms of these agreements being indentures, which is a type of contract for land. So they're moving away consciously or unconsciously from the old idea of relationship and sharing territory towards a much more European notion of alienating land. They're talking contract, essentially. The second big difference is that compensation now takes the form of annuities. Smaller amounts in compensation, but paid annually, not just once up front. This kind of compensation was in fact quite welcome to First Nations because the idea of annual presence was deeply embedded in the whole notion of making and renewing relationship through ceremonies. In fact, down to 1853, the annuities for treaty compensation and the present giving continued together, as I say, down to 1858 when Britain, for economic reasons, eliminated the giving of the non-treaty presents. But that is the second phase, and it opened up an enormous area for settlement because the non-native population of Upper Canada essentially increased by a factor of 10 between the War of 1812 and the 1850s. And what happened was, in spite of the Royal Proclamation, in spite of the treaties, all too often the First Nations found themselves literally marginalized, pushed to the margins, dispossessed, their fishing sites despoiled, and having all kinds of problems. So the Royal Proclamation could and only did so much to protect them. The fundamental problem was the Indian Department was always more willing to be conciliatory to settler opinion than to the opinion of First Nations First Nations were declining in numbers as a result of disease in this period as well. And then the third phase of this first redefinition in 1850, and then actually in 1862. And it comes as treaty making moves north. And you have the Robinson-Huron Treaty and the Robinson-Superior Treaty. This is a big change. This is a refocusing of the interest in First Nations land, because the interest now is not for agricultural land, but for resource-rich land. Mining is beginning in the 1840s up in the Algoma region around Sault Ste. Marie and up on Lake Superior. Americans are mining aggressively in Michigan Peninsula by this time. The Robinson treaties add more elements to what's becoming a Canadian treaty-making tradition, a kind of protocol for making treaty. Because Robinson is a shift to, as I say, raw materials or natural resources. Robinson deals with large tracts of land in contrast to the much smaller areas covered in southern Ontario as it now is. And Robinson introduces explicit promises of continuing Aboriginal hunting and gathering rights that had not been in the early treaties. One other innovation in 1850 is the introduction of reserves. Promises to create reserves become part of treaty making in Canada. And if you've been paying attention, you didn't hear me say the word reserve till 1850. There were some reserves before 1850, but their creation had nothing whatever to do with treaty, either in the Maritimes or in Upper Canada. They were created as kind of refuges for those peoples who were being marginalized and dispossessed to try to provide them some limited protection from the processes that were going on. What's happening by the 1850s, and if I could just conclude the Upper Canadian portion, the similar pattern to Robinson is repeated on Manitou Mound in 1862. What's happening in Upper Canada by this time as the settlement frontier becomes very well established and First Nations are getting marginalized and dispossessed is the attitude of the Indian Department shifting towards First Nations. First Nations are no longer valued as commercial partners, as trading partners. They're no longer valued as diplomatic allies and military allies, because with the end of the War of 1812 and the creation of the Rushbaga Convention of 1817, which demilitarized the lakes, the American danger is believed to have disappeared, so they're not needed or wanted as allies. And so First Nations in Upper Canada, as would happen in other parts of the country later, are becoming administered people rather than trading partners and allies. And this painting is called Numbering the Indians. If you know anything about state formation history, you know one of the things the state does when it's going to administer you is it counts you. And that's what's going on at the Democon, essentially, in that illustration. And that is the first redefinition or refocusing of treaty making occurring in Upper Canada, or the Canada West portion of the United Province of Canada after 1841. It's a very important change because it creates a brand new template for treaty making that will be applied in future. After Confederation, what had been done in Upper Canada will be done again in the West. In fact, Treaty Commissioner Alexander Morris would say, and he made many of the treaties in the West, that the Western treaties were in fact based on the Robinson treaties. They followed the same pattern. Why were post-Confederation Western treaties similar to Upper Canadian treaties? Because the people in charge of policy making, like MacDonald, had learned the ways of dealing with First Nations in Upper Canada and in the province of Canada in the 1840s and the 1850s. And when they had to deal with First Nations in the West after 1869, the acquisition of Rupert's Land, they reached automatically, well, not quite automatically, they reached eventually for what they had seen done successfully in avoiding war in Upper Canada. I say they didn't do it immediately and automatically because their first step was, of course, a misstep. The first step was to ignore the Métis in Red River in 1869 when they moved to take it over. And what they got for their pains, of course, was the Red River Resistance. Well, that reinforced the lesson that maybe it was better to negotiate with the First Nations in the West. The Métis numbered roughly 12,000 in and around the Winnipeg area. The Plains First Nation, numbered in the tens of thousands, had a reputation of being formidable warriors to boot. So Canada moves fairly quickly to open up the West as Canada saw it for settlement. And it does so between 1871 and 1877 in a series of territorial treaties known, imaginatively, as the number treaties. Treaty 1, 2, 3, 4, 5, 6, 7, essentially. And these treaties gain peaceful acquisition to Western lands. They constitute an enormous empire, roughly from Lake of the Woods on the east to the foothills of the Rockies on the west, on the international boundary, on the south, to a point midway up the prairie provinces to the north. And they have annuities, and they create reserves, and they recognize hunting, gathering rights, and they do all the things that were done in the Robinson treaties. One of the interesting theories, one of the interesting developments of the number treaties of the southern number treaties in the West in the 1870s is you see a big return of ceremony occur. And the reason for that is fairly straightforward. It's because the leaders of the Western nations, people like Atakakup on the left front, for example, or Mistawasis, had learned their ways of dealing with the European and the Hudson's Bay Company fur trade. And so when they turned to deal with the government, they didn't really realize they were dealing with something different, and they insisted on the same kind of ceremony. Welcomes, feasting, pipe ceremonies, sometimes equestrian displays to boot, so that ceremony makes a return. The other thing that Western First Nations bring back into making treaty in the West is a notion that's directly opposed to the notion of contract that had crept in after the War of 1812 as far as government is concerned, indentures or contracts. Because that's not what it is to Western First Nations. These are not contracts. These are covenants. This is not about land transfer. This is about creating a relationship. What's a covenant? Well, if you've ever attended a Christian marriage ceremony, you've been present at the making of a covenant. A covenant is an agreement between two or more humans and the deity, essentially. And in the value system and cultural practices of Western First Nations and other First Nations, these agreements were covenants that involved the Great Spirit. After all, we smoke the pipe. When you do that, you bring the Great Spirit into the process, and you bind the parties to speak truthfully. If it's not about covenant, then why were your commissioners always talking about doing things in the eyes of God, and even referring sometimes to the Great Spirit, for example? So the view of Western First Nations has always been that the treaties are much richer than government was insisting they were by this time. They were covenants, and that is a very potent notion. There are covenants about relationship, and relationship isn't contract, and when things get difficult, members of a relationship help each other. They don't just go to law or the court to enforce a contract. And the reason that Western First Nations are so bitter about the treatment they've had under treaty is that they believe, not without reason, that they had been sold all kinds of promises when they made treaties in the 1870s, and then Canada switched. Didn't work according to the spirit and intent of the treaties. Instead, Canada administered them under the Indian Act, which Parliament passed in 1876. From the very beginning of the Western treaties, there has been this fundamental difference in perception, understanding, and approach. And what's happening only in very recent decades, the last 15 to 20 years, is that slowly the government is being brought back to a more traditional understanding of and approach toward treaty making that involves these notions of relationship, essentially. Sometimes they're brought back kicking and screaming, but they are eventually brought back. After 1877, treaty making stops for 20 years, roughly, except for a big adhesion that occurs in 1889 in Saskatchewan, known as the Montreal Lake Adhesion. The reason was that Canada had acquired all the agricultural land it thought it needed for immigration and settlement. And its attitude towards treaty making was, well, we only make treaty if it's just something in it for us. And we've got all we can handle now, so we're not interested in treaty. And we're not interested in talking about the spirit of the treaty, we're talking about the terms of the Indian Act, essentially. You can understand why First Nations felt betrayed in such a regime. First Nations throughout the period after 1877 often petitioned frequently to be taken into treaty. Pardon me. And Canada said, no, we're not interested in your lands anymore. Until 1899. Just before that, gold was discovered in Klondike. And Canada began to worry about routes to the Klondike, and in particular the overland route through northern British Columbia into the Klondike. And First Nations were resisting prospectors and miners going through there without their permission. It was causing problems. So all of a sudden, the government's attitude changed. And it makes Treaty 8, which, as you can see, covers a very large area of northeastern Saskatchewan through to northwestern BC. It's once the northern resources become important to Southerners and their government that Canada's tune changes. The spirit of treaty making in the era of the Northern Treaties, 1899 to 1921, is really typified by this man. This is Duncan Campbell Scott, long time, almost 50 years service in the Indian Affairs Department. He was the Chief Federal Commissioner of the next treaty, Treaty 9, the James Bay Treaty in Northern Ontario. And he was notorious for his hard-hearted attitude towards First Nations, though he thought he was a philanthropist and did benevolent things for them. He's the man who said before a parliamentary committee in 1918, quote, I want to get rid of the Indian Act. And he wanted to get rid of Indians. He didn't mean exterminate them. He meant eliminate them as a legal category and eliminate them culturally through assimilation. It was a pretty harsh attitude, but it was a pretty honest statement, because that indeed was Canada's attitude in the 20th century for a long, long time. And that was the sort of attitude that Duncan Campbell Scott and other treaty commissioners took into the making of Treaty 9 and other northern treaties after 1906. Treaty 9 was made. Treaty 10 actually just covers the northern strip of Manitoba and Saskatchewan, largely tidying up boundaries there, although there is an interest in guaranteeing access to resource-rich areas as well. The final Northern Number Treaty really bears out what I was saying about Canada's opportunistic and selfish attitude toward treaty making. Treaty 11 is made in the Southern Territories, and First Nations there had been petitioning for decades after 1877, and Ottawa had always said, no, we're not making treaty because we're not interested in those lands, until in 1920 oil was discovered at Norman Wells. 1921, Canada makes Treaty 11 with the First Nations of the region. It's the most graphic example of the way Canada is motivated or not motivated to make treaties. By the time we get to the northern treaties, including Treaty 9, really ceremony has almost completely disappeared from treaty making as far as the Euro-Canadians are concerned. This is one of the few examples, and it's not really clear that the treaty commissioners knew what they were doing in this, because they're approaching a treaty negotiation site with a flotilla of canoes arranged in this way with a leader in the center. What this is a replication of the way the First Nations used to approach the fur trade post canoes. As they got close to the Hudson Bay Company post, they would stop, go ashore, put on their best clothing, paint their faces, and then approach, if the river was wide enough at least, in that way, flying manner. So whether Canada realized what it was doing or not in 1905, 1906 in Northern Ontario, it was replicating ceremony. The other aspect of ceremonialism that is found in a number of treaties, including Treaty 9 in Northern Ontario, is the feast. This is the Feast of Metagamy after the treaty had been negotiated there, essentially. And that's all there is anymore. All the richness of the language of relationship, our great white father, our great white mother, the queen, of brotherhood, of sibling relationships, and all that stuff is all gone, essentially. You've got a new and hardened attitude on the part of the First Nations, pardon me, non-First Nations people in the treaty negotiations. And that's it for 50 years, except for 1923 when there's two dubious documents known as the Williams Treaties, negotiated or at least signed in Ontario. And what they really do is clean up some of the sloppiness that had occurred much earlier in Upper Canadian treaty making. But there's no treaty for 50 years because I want to get rid of the Indian problem. I'm not interested in creating relationships with Indian people. We've got all the land of theirs we need. Why would I get treaty? It's a new and a much harsher attitude. Until, again, conditions change. They change in the 1970s. And they changed primarily for two reasons. Supreme Court of Canada in 1973 issues a decision, what's known as the Calder case, the Nisga'a case. The Nisga'a had been fighting for recognition of their lands in the Nass Valley since the 1880s. And they would go on to fight for it through into the late 1990s till they finally got the Nisga'a Treaty. But the Calder decision, Calder was himself a Nisga'a man, was very important in sending a message to government, because what the Supreme Court said in Calder was that there was something called Aboriginal title that did exist in Canadian law. It was real. And governments had denied the reality and validity of Aboriginal title to that point. They couldn't deny it anymore. No one knew what it meant exactly or how you dealt with it, but it existed in law, and that was important. And around the same time, something else happened that was extremely important, and that is the long history of the provincial and federal stages running roughshod over First Nations and resource development came to a crashing halt, or at least delay. In 1970, Premier Robert Bourassa of the province of Quebec announced the project of the century. They were going to create 100,000 jobs in Quebec. And they were going to do it by drowning the lands of the James Bay watershed. It's only a few thousand James Bay Cree there, what does it matter, right? And really, that's the way Canadian provinces and crown corporations had operated for decades, for generations. So he wasn't doing anything new. It had been going on right across the country. What was new this time was the James Bay Cree said, oh, no, you're not. And they resisted. And more to the point, they resisted effectively. They were developing a new cadre of very able leaders, including a very young but very smart and very tough guy named Billy Diamond. And so the James Bay Cree went down to Montreal and they hired themselves a very aggressive, imaginative lawyer. And they went to court and they applied for an injunction to stop the James Bay project in its tracks. And to the amazement of everybody, including the lawyer for the James Bay Cree, because I've interviewed him, they got an interim injunction in the court. Now, the injunction was overturned very quickly. An injunction to stop road building and all the other work to build the James Bay Power Project. They got that injunction overturned very, very quickly with insanely indecent haste, in fact, under very dubious circumstances, but that's another story. It didn't really matter. The point had been made. And the Maloof injunction, in concert, in combination with the Calder decision the following year, sent the message, you'd better negotiate or you're going to run into trouble. And so that's what then happened. Between 72 and 74, Quebec, Canada, and the James Bay Cree negotiated what became known as the James Bay and Northern Quebec Agreement of 1975 to cover this region that Quebec wanted to develop for hydroelectric power. I haven't time to go into the details of it, but it's a very rich and complicated agreement. But more to the immediate point, It stopped that long, it ended that long hiatus. It reintroduced treaty making. James May in itself was a reintroduction, and also related. Pardon me, did I miss a slide? Yes, I missed part of the slide. Sorry. Also closely related was that Canada said, well, we really can't go on just denying Aboriginal title or refusing to do with it. And in 1973-74, the government of Canada created the Office of Native Claims, which dealt with 3 categories of claims, but the one that matters to the treaty story is comprehensive claims. Comprehensive claims are claimed by a First Nation that their Aboriginal title to territory is unextinguished. They've neither given it up by treaty nor been conquered militarily. So it still exists. So Canada set up a mechanism to investigate and sometimes negotiate a settlement of comprehensive claims. And comprehensive claims settlement under our Constitution, especially since the 1982 Constitution, are modern day treaties. So that creates a new category of treaty making in the 4th era of treaty history. Those treaties negotiated under claims, as they refer to it in Ottawa. Also, what occurs, particularly in British Columbia, is in the 1990s you get established what's known as the British Columbia Treaty Commission process. British Columbia denied the validity and reality of Aboriginal title for 120 years. Even after Calder, they continued to deny it and refused to negotiate about it. And then in 1990, there was another Supreme Court decision, which was called the Sparrow decision. And it didn't actually deal with Aboriginal title, but in the course of their ruling, the justices made it very, very clear that they thought Aboriginal title was real, and governments had better deal with it or it was going to be difficult. And then BC changed its tune, fell in with Canada, which had been wanting to negotiate for a long time, and they entered this tripartite process. Can't be described as exactly a smashing or immediate success after 18, 19 years. We've spent billions of dollars and we have 2 ratified treaties, but there's 6 more close to ratification. There's 60 other sets of negotiations going on, and when people complain about the BCTC process, you have to reply to them, well, so what's your alternative? Because as faulty and slow as it's been, there really isn't another game in town in BC. But this too is part of the 4th era of treaty making, the BCTC process basically. So if we look back on 400 years from the vantage point of 2011, then we see these phases. Commercial compacts and deferred trade, treaties of peace and friendship, Royal Proclamation introducing territorial treaty making in the late 18th and 19th century. And we see how that gets shifted and redefined a couple of times in Upper Canada, in Ontario. And then we see the prototypes from Ontario being transferred to the plains in the western woodlands between 1871 and 1921. We have a hiatus for 50 years, and then we have the modern era with comprehensive claim settlements and with BC Treaty Commission process. 400 years, what could be described as 4 phases. It seems to me it's a very rich, complex, impressive history that's not very well known, but deserves, I think, to be better known. And to repeat, Ontario is the site, is the arena for major redefinitions along the way in that story. Because it's a long way from the approach of the forest diplomat William Johnson in the 1750s, 60s, 70s, and the attitudes, I want to get rid of the Indian problem, of Duncan, Campbell, Scott in the 20th century. Ontario is where the relationship is first redefined, and that's an extremely important part of the treaty history story. Thank you.